You know, I'm used to not speaking in front of so many people. It's usually 12 people at a time, and they're also painted to be there. So I'll do the best I can. Thank you, Brad. What I'm going to talk to you about briefly today, famous last words from any trial lawyer, is some things that may be of interest to you in the area of medical malpractice. I've been exclusively representing doctors in at least one hospital since 1986, and I've had the privilege of representing a number of specialties. You'll be pleased to know that I've only had about 1 or 2 ophthalmology cases. Got one now. I had one years ago. We got it dismissed. So I think as far as your specialty, you have what we call, you're not a frequent flyer in my business. You'd probably be pleased to know that. But if you've got MD behind your name, it does not stand for medical doctor. It stands for malpractice defendant. So just if you got MD behind your name, you're a potential target. And we're going to talk a little bit about that. Maybe some things I say and share with you today will help you in your practice just be a little more acutely aware of risk management and avoid a lawsuit. So, but what we're going to talk about today is why do doctors get sued? We're going to explore some of those things with you. But things that you really don't want to hear in the operating room. Hand me that thingy. Could you stop that thing from beating? It's really throwing off my concentration. I better save that. We'll need it for the autopsy. What's this thing in here? You can tell it's about general surgeons. It's not about ophthalmologists. Oh, no, I just lost my Rolex. Dang, I hate it when that happens. Oops. Hey, has anyone ever survived 500 milliliters of this stuff? Wait a minute. If this is explained, what's that? Don't worry. I think it's sharp enough. Anyway, things you don't want to hear, particularly as a patient in the OR. Well, what is medical malpractice? I'll give you the very brief legal definition. This is the definition in South Carolina where I practice. We're in Georgia where I'm also licensed, but I don't practice. The definition of malpractice is pretty much the same all across this country. And basically, it is this. Ready? It's what the reasonably prudent physician would do or would not do in the same or similar circumstances. That's it. Fill it in more specifically, what the reasonably prudent ophthalmologist would do or would not do in the same or similar circumstances. That is the legal definition pretty much across this country of if you do something most folks don't do, that reasonably prudent ophthalmologist, then you're liable for malpractice. Well, let's talk about, that's all you need to know about legal definition. Why do doctors get sued? The retrospectoscope, every plaintiff lawyer has one. Every one of his $500 an hour experts has one. There's a case I tried years ago, a family practice doctor who took an x-ray, chest x-ray of a gentleman. It was kind of dark. Sometimes those chest x-rays don't show very well. It was kind of dark and kind of fuzzy, and he did not see this little white mass in the left lower lung base. Patient came back about 6-8 months later, had metastatic lung disease and metastasized to his brain. Sued the family practice doctor, and we went to trial and defended the case, saying that, well, you know, it was just hard to see, and you know, things happen, and let's just defend ourselves here. So we did. And the plaintiff lawyer, who has a burden of proof, by the way, and the burden of proof simply means they've got to prove their case. They have the burden of persuasion. It's, in civil cases, it's ever so slightly. The scales tip ever so slightly in their favor, they win. Which means if they tip ever so slightly in the doctor's favor, we win. Or at the end of the case, if they're even, we win. So we got 2 out of 3 chances. It's good. But they've got to tip that scale ever so slightly in persuasion. So they hire these good experts. And in this particular case, they hired a surgeon to come in and demonstrate to the jury what my doctor should have done with this dark, fuzzy x-ray. Yeah, sometimes that happens, you know. I said, well, when that happens, every good doctor ought to have a hot lamp. And he picks up a hot lamp that he brought into the courtroom, popped it up on the tripod, turned it on, and, you know, of course, it's got that little protective grid there so you don't, you know, scorch yourself. And he kind of held his hand out in front of the jury and says, yeah, that's really hot. Yes. Well, they call it a hot lamp, you know. And so what you do is you take the x-ray, and he took the original x-ray that was in evidence, this kind of darkened x-ray, and he held it up to the hot lamp. He says, now see, when you do that, you can see these things a little bit better. And things started melting in front of the jury. And I'm sitting there watching it, and I jump up and I say, Judge, he's destroying evidence. And the plaintiff lawyer's eyes were kind of big, you know, kind of like, oh my gosh, what's going to happen? And the plaintiff lawyer, good lawyer, said very quickly to the judge, oh, we got a copy, Judge. And I go, but Judge, that's the original. Like it matters, you know, who cares? And so, you know, the expert was kind of flustered and all that. And anyway, so I got the closing argument, which is always my fun part of the case. And I waited and waited and waited. And I got to that point, and I had two exhibits I was going to show the jury. And one of them was this. This was way back when. This will date me. You remember the magic eye when that was real popular? You know, you look at that thing. You guys probably do it all the time. You look at the magic eye thing, and you don't know what in the world it is. And you kind of have to, you know, sort of squint your eyes and sort of do this. And eventually, you know, it comes and folks say, oh, I see what it is. Well, I had this big magic eye poster. And I held it up in front of the jury. I said, this case, ladies and gentlemen, is retrospectoscope. This is like the magic eye. Now, you see this poster, and everybody's going, yeah, kind of squinting their eyes. The judge was kind of looking around. And so I said, see, this is what this case is about. It's retrospect. It's retrospect. It's hindsight. Now, I've studied this, and I know what this is. I'm just like that expert witness who studied the other x-ray. Oh, yeah, there's a big white spot here. And I go back and, oh, yeah, now I can see that one in that dark film. I said, that's all he's doing. I said, it's just like this magic eye. And they're all still kind of looking, trying to figure. I said, and I'll tell you what it is. This is Pegasus on a horse in the mountains. And they're all going. A couple of them going, oh, yeah, yeah. A couple of them. I got 12. All right, 2 out of 12, right? And so I was just trying to illustrate the point. When you know it's there, you get it. It's a retrospectoscope. And then I waited for this. This was the most fun of that whole trial. Then I picked up that original x-ray that their expert had melted in front of them. I said, and ladies and gentlemen, how are they going to prove their case? They got an expert who can't even handle the original x-ray. I said, that's their evidence. That's their persuasion. About an hour later, they returned a verdict for my client. Now, the patient was sitting there in the courtroom alive. He had survived metastatic brain cancer, was a mover. He moved furniture and stuff, and his measure of damages, I was briefly with this, a wonderful old guy. We were glad he was alive and survived all this. And he said, well, how has all this affected you, Mr. Plaintiff? Well, I used to be able to carry a pen upstairs and downstairs by myself on my back. I can't do that anymore. Gee, okay. A happy ending. Failure to order tests and diagnostics. If you don't order a test, and if you don't order a certain diagnostic test that you could have, not that it was medically indicated, forget that, but if you didn't, and you could have, the plaintiff expert says, that's a deviation from the standard of care. Every reasonably prudent ophthalmologist would order that test. And that's how they do it. It's the retrospectoscope. Failure to prescribe antibiotics, always a favorite with the plaintiff lawyers, always a favorite with their experts. Well, all they had to do is just give a little, empirical antibiotic, just give it to them empirically. Forget it. Don't wait for the cultures. Just give it. They didn't give it. They should have given it, and the person wouldn't have had sepsis or whatever. And then just move on from there. So, failure to give antibiotics, a favorite theme. Misdiagnosis, always a big deal. Well, you didn't even consider it on your differential diagnosis list. So that my client is testifying, well, I never considered, I never did consider that on my differential diagnosis, appendicitis. Why was that? Well, the patient was 56 years old and yada, 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 and she goes through her thinking. And at the end of the day, of course, the patient got, ruptured appendix, almost died of sepsis, did survive, sued us. And the whole problem there was you never even considered it. Had good reasons medically not to. We settled that case before the jury returned a verdict against us. Those are the kind of things that you run up against in this retrospective. Hindsight is always a wonderful thing. Last hour we saw that crystal ball that was kind of fuzzy. In the plaintiff's world, the people suing you and their experts testifying against you, they have the best crystal ball in the world. And it's always right because they're looking back through it. And it can be a real trap. Informed consent. Let's talk about that just a second. What's legally required? You know what's legally required. How do you know? Because you do it all the time. What's legally required, I'm going to summarize this for you for sake of time, is this. Tell the patient what the procedure is. Explain the operation, the procedure, treatment. Particularly, this is a surgical procedure. I'll refer to that. You explain the alternatives. You can do nothing. There are other options we can do. We can do this or that or the other, or do nothing. These are the general risks. These are the known risks, the specific risks and complications that are possible, and you don't have to list all of them. That's not required. Ask them if they understand. Get some understanding and document it. That's what's required. Give it well. Be sure they understand it well. And this is a lawyer talking. Document it well. What you said and what the patient said. Quotes are good. Quotes are really good. Quote, patient said, I understand, I want to proceed with the surgery, end quote. That's fine. Or you can just paraphrase. You can just say, well, patient verbalized understanding. You probably use that. I've read that a lot. That's a good thing to do. Patient had question. Patient decided they would think about it. Discuss with patient and his wife. That's always nice if they're both there, and document that. If they ask questions, document the questions. Patient asks about the complication of X. Explain Y, Z, etc. It's a documentation issue. You're doing it. Get credit for it. If you get sued, this will save your can. I promise it will. It's always an issue that comes up in every malpractice case I've ever had, informed consent. As soon as they see your documentation, it stops becoming an issue if you've documented it well. But they're always going to bring that up. It's sort of it comes with every lawsuit. Document in your office note. Document it in your history and physical if you're admitting a patient to the hospital. Advise patient of general risk of the procedure in the office, verbalized understanding, ready to proceed, wishes to proceed. Document in your op note. You're going to dictate an operative note. Covered informed consent, and then get into your operation itself. Don't have to, good thing to do. Other reasons that patients may sue you, patients or families' anger. For example, sometimes a patient or a family misperceives, or maybe, unfortunately, correctly perceives your attitude or lack of it when you get a bad result or you get a complication. Stuff happens. How you handle that is going to determine not whether you get sued sometimes, but how well you can defend yourself. Explain it to them. Talk to them about the complication. Talk to them about the bad result. Apologies are good if they are appropriate, but be careful. I'm sorry. I can see a wreck happen at an intersection, and I don't even know the people involved. And somebody's hurt. Ambulance comes, and obviously, it's blood, and it's terrible. And I can say, I am really sorry that happened. I didn't have anything to do with it. So you can apologize for a misadventure. You can apologize for a complication or a bad result that causes pain financially or otherwise to your patient without admitting liability or responsibility. But be careful, because they hear I'm sorry as an admission of guilt and liability. So you need to be honest, but you need to be wise. Sometimes you have guilt by the family, not yours. They feel guilty about the decisions they made. Gee, they should have brought Dad into the hospital. They knew his abdomen was hurting. They knew he was going downhill. He had these medical problems, and they just waited till they brought him to the doctor's office. Well, the time they got him to the doctor's office, he had peritonitis, he had sepsis, and he had passed the point where he could be operated on. The surgeon couldn't do anything about it at that point, and they sued the doctor because they really felt bad. We should have brought Dad in the day before or 2 days before. And so to assuage their guilt, they'll file a lawsuit just to look for some closure. That happens more often than I can count. Unanswered questions. Most patients and families want to know what really happened. There's a medical economics article some years ago. I'll just read it very briefly for you. What most plaintiffs really want is to find out why the tragedy happened. They want to know why the doctor would not explain it to them or why he would not return phone calls. That's why they turn to doctors or to lawyers. Yeah, the 1 in the 250 that we saw earlier. For example, a patient, this is an actual case, a patient died following a laparoscopic cholecystectomy. That's a gallbladder disease for you eye doctors. And at autopsy, approximately 25 milliliters of pretty fresh blood was found in his peritoneal cavity. There was an autopsy and a conference after the autopsy with the surgeon and the family. The family wanted to know what happened. That's all they wanted to know. Tell us what happened. With the autopsy in his hand clearly showing what happened, his comment was, quote, "We'll never know what caused his death," end quote. Lawsuit settled in the family's favor. There was obvious intraoperative bleeding. It was a misadventure. It was misdiagnosed and a delayed diagnosis, and the patient died. Family went to a lawyer, sued the doctor. The lawsuit was settled. That wasn't my case, by the way. But we do settle cases. Why do they sue doctors? It's all about money. Secondary gain. Show me the money. A lot of people look at a lawsuit as a really expensive lottery ticket. In South Carolina, it costs about $120 to file a lawsuit. That's the filing fee. The plaintiff lawyers, their motto is, we don't get squat unless you get a lot. So there's no upfront cost from their perspective for the plaintiff. $120, good lottery ticket. You know, the chances are a lot better at winning it with a malpractice case and getting money than they are a lottery. And lottery tickets, I've never bought one. I'm thankful for the people in South Carolina who did it, put my kids through school. Thank you. But I think they're a lot cheaper than $120. But that's the way people look at it. A lot of plaintiffs will say this, and you'll hear them, if you've ever been sued, you'll hear the plaintiff say this, or the family. You know, I just don't want to see it happen to anyone else. I do malpractice defense work. That's all I do. But every now and then I get somebody coming in saying, I just had this little accident, and Mr. Lawyer, can you represent me? And I'll talk to them. I mean, you know, what the heck? I'm making a little quick money every now and then. That's okay. I mean, it's clear liability and injury and damage. That's fine. I'll do that. I've had 3 of those in 20 years. But anyway, I never retain them as patients or clients, because I get to that point when they say to me in my office, you know, it's not about the money. It's about the principle of the thing. And I just look at them. And when I hear them say that, I'm going, really? And so I say, well, I'll tell you what, Mr. Prospective Client. I said, I appreciate what you're saying. I believe you. I think that's right. I'll tell you what, we'll go ahead and take your case. We'll file the lawsuit. And if we settle the case, or if we go to trial and we get a verdict, what charity do you want me to donate your money to? Because it's just about the principle. It's not about the money. I mean, right, I'm going to take my fee, okay? But I've never had a good answer to that question. It's usually well, I appreciate your time. Is there somebody else out there? Yeah, go see my friend down the road. He'll help you. So I don't get those cases. The plaintiff lawyers, the John Edwards of the world, they have this rationalization that sounds like this. It's about justice for the little guy. No, it's not. It's about money for their bank account. But you hear them say that, and they get on their high horse, and they think, you know, I hear that a lot. I've yet to meet the one that really believes that. I know he's out there. He's just not in South Carolina. Bottom line, it's all about the bottom line. So how do patients perceive doctors? How do patients perceive doctors? There are some negative perceptions. Duh. How many patients become jurors? That's what you need to really worry about. Every juror I've ever had, and I get 12 at a time with a couple alternates, so 14. Trials that I try usually last all week. These people are subpoenaed to be there. They don't want to be there, but they're there. And there probably aren't many times in the last 20-some years where I've had people of 12 citizens that are subpoenaed to be on a jury that haven't been a patient somewhere, or I hadn't had a family member a patient somewhere. Every patient you have is a potential juror. Now, that may not, you know, that doesn't mean they're necessarily going to sue you, but there is a perception of lay folks of you as physicians. They carry those perceptions that they form as a result of being in your office and under your care into that jury box. Y'all help me. Help me here. Do a good job. Give me some good patient situations when they step in that jury box, and so that they have a positive perception and not a negative perception of doctors. Some negative perceptions that we've heard about in the past: long waits in the waiting room. Man, that's tough. Y'all have been patients. You know how that works. We all have been. And I will tell you that I have had cases where the doctor's gotten sued, and you know, that comes up. We waited. Typically, it's an ER case, and that's not your situation. But, you know, ERs, you're not going to be seen for 3 years. But that's not your situation. In an office setting, it's tough because you got a big practice. We just heard the last hour with 25% increase in your patient load. Hello, you got to accommodate the space and the time. Well, they're going to be stacked up like planes in LA on a real foggy day. I mean, they're going to be waiting, and you can't help that. But you can help the perception about it. That's a perception they're going to carry with them. You seem too busy or in a hurry. Why? From what you heard the last hour. It's not that you're lazy. It's not that you're inefficient. There's the Dr. Ugly thing that they have a misconception about. You know, what kind of car are you driving? You know, oh, well, he drives like my friend Brad, who's driving how many, 160,000 mile. What you got? I drove up here with you in that thing. Anyway, time, they will testify as plaintiffs and witnesses about how long it took. Now, if you're doing it right, your patients are going to wait. I mean, that's going to happen. That's okay. But here's a real good thing that you can do, and most of you are probably doing this. If when you have the time with your patient, you can maximize the patient contact, you can maximize the communication, and maximize the feel-good experience they're going to have with you in that one-on-one situation as their patient in the office, they'll go back, they'll wait twice as long the next time because they know they're going to have your undivided attention in that room, and they'll never complain about it. I've seen that. Recent plaintiff attorney themes. What is safe, or the safest way to practice medicine? You will hear plaintiff lawyers, if you've ever been anywhere around litigation, anytime in the last 5 years, and from here on out until they come up with a new theme, talk about, well, what's the safest thing? Let me give you an example. Emergency room situation, good ER doc, pretty good ER staff, but, and I represent the doctor, not the hospital, who settled. But the emergency room doctor was taking care of this lady, examine, re-examine, EMRs, document everything that's going on. Everything, is on a computer screen in the ER. And the nurses are responsible for taking and documenting vital signs. And the plaintiff lawyer says, well, doctor, why do they call them vital signs? Because the vital signs are vital, aren't they? I mean, what are you going to say to that, Doc? No, we just call them vital signs. They're not really important. Yeah, they're important. Kind of like heart rate, like tachycardia being over 100. Yeah, that's kind of important with somebody with diffuse abdominal pain. And so the nurse in that particular case took a vital sign late in this lady's stay, moments before my client doctor did his discharge exam and wrote discharge orders from the ER, and just didn't tell the doctor about it. Did she document it? Yep, so it's somewhere on that computer screen somewhere, in there somewhere. Had a heart rate of 118. 100 is tachycardia. She took another vital sign after he had ordered discharge and prior to discharge at a heart rate of 120. Didn't tell the doctor. Documented it, it's in the record, but didn't tell the doctor about it. The issue was, well, doctor, my client, wouldn't the safest thing to be for you to go and check all these computer charts and be sure everything in there, you reviewed everything, the whole chart and everything that happened? Well, that was the question. And he stumbled through that answer, didn't do a real good job, but he did the best he could. Our expert witness, who was an excellent emergency room doctor, our expert witness, when he was asked that question, answered it this way, because we said, oh, they're going to give you the safest, da-da-da-da-da. He says, well, let me explain my answer to you, Mr. Lawyer. The safest thing, in my opinion, as an emergency room physician, is for the nurse to tell the doctor when there's a elevated heart rate. That's the safest thing. Now, the hospital already settled. The nurse had testified that I didn't even consider anything over 120 as tachycardia. She was no longer with the hospital at the time. So those kind of things happen. But it's the safest thing. Well, what's the safest thing to do? That has nothing to do with the standard of care. Does any treatment that you give, does any medication that you give carry with it certain downward risks and complications? Hello? Does that mean it's safe? It's a risk-benefit analysis, and you know that as physicians much better than I do. Everything you do has a risk-benefit analysis, and that's what you do. You're not saying, what's the safest thing? What's the best thing for this patient under the circumstances, given the diagnosis, and what's a risk-benefit analysis? And that's where you go from. The safer thing is a manufactured theme by the plaintiffs. Some practical advice, and you're already doing this, so I'm just going to run through this real quick for sake of time. Pay attention to the patient's time as best you can. How do you do that? Well, just get in the room and say something. Gee, I'm sorry you had to wait. You can probably assume they had to. It goes a long way. Avoid delays. Apologize for them when they happen. Gee, I'm sorry you had to wait. I'm glad you're here. Let's talk about this. Try sitting down in your room as soon as you come in with your patient. There's studies that have been shown from medical economics. When a physician comes in the room, sits down and talks to his patient and goes through the Q&A and whatever he's going to do for that particular visit in any specialty, and then finishes what he has to do and leaves, the patient's perception is the doctor spent a lot of time. How much the doctor spent? It was like 10 minutes. They clocked it. It was like 5 every time. But when the doctor stood up, how long was the doctor in there? He was only a couple minutes. It was 5 minutes. It was 5 minutes all the time. So, you might want to try that. If you don't have a stool in the room, try getting one. Try really hard to listen to their questions. That can be tough, particularly when you get that patient who comes in to you and says, do you have any questions? And they whip out their, iPad or their, yellow pad. I do have a few questions. And you kind of go, I won't be on for dinner tonight. But you got to try it. Ask questions. Do you understand what I'm talking about? How about the treatment I'm prescribing? Do you understand why we're doing this? Okay, you have any questions? Thank you very much. Try calling your patients the day of evening before surgery or after surgery. That's tough to do. That's really tough to do. It is incredibly effective, but they're just ideas. You may be doing them. Does your patient understand why you're recommending the treatment or procedure? How do you know if they understand it? Unless you ask them. They're going to say yes anyway. Just go ahead and ask them. Oh, yeah, I get it. Try calling. Oh, we did that. Oh, yeah, that last one. Do not do this. This happened to a good doctor who was taking care of my wife, and I was in the room with my wife when she was being seen by this good doctor. And the doctor just said, okay, well, you have any questions? My wife has always a lot of questions. And she asked a few questions, and I'm, listening, and the doctor's answering the questions. Everything's good. And the doctor just said, okay, well, all right, fine. Well, wait just a minute. Got up, walked out of the room, and we're sitting in there, and we're sitting there, and we're sitting in there. I mean, seriously. And I'm going, what's going on here? And she never did come back. Finally, her nurse came back and said, okay, we're ready to check you out. And my wife looked at it, what? Don't do that. That's really not good. She's a good doctor. We didn't sue her. Everything's fine. There really is some malpractice out there. Why do doctors get sued? 3 quick examples. A Kelly clamp. Y'all know what a Kelly clamp is? Intra-abdominal surgery. A guy had part of his intestines removed for cancer. The assistant surgeon was holding the Kelly clamps, and the main surgeon said, hey, I need an assistant to tie off this suture here. The assistant surgeon let go of the Kelly clamps he was using to retract the anterior abdominal wall, and they just flipped. And nobody saw it. I mean, it was just like, and I think it was 3 weeks later, the fellow kept coming back with continued abdominal pains post-op, 3 or 4 weeks, and they said, well, let's take an x-ray. Have you ever seen a Kelly clamp on a plain film with the small bowel migrating through the thumb hole? It's an impressive picture. Another case where a lady almost died, really. She was having GYN surgery, and she started bleeding. And I mean, I'm telling you, they were throwing everything in the world in there to try to stop that bleeding. Lap squares, which have those radiopaque threads, and all this other stuff. Well, guess what doesn't have a radiopaque thread? The hospital towel with the hospital's initials on them that got in there. She kept having these abdominal pains, and finally they thought she had cancer. The CT scan showed a little mass. Oh, my gosh. Goes down to Medical University of South Carolina, a very good surgeon, operates, and says, well, what's this? And pulls this blue towel out. And strings, that had been there about 1.5 years. It was pretty grody. But it still had Mary Black Memorial Hospital printed on it. Yeah, that case got settled. I won't go with misread CT scan. This is really want to get to. Well, before I do that, let me look at my time. Okay. Want to bring you some reality. I'm telling you war stories, but here's one. Just a little drama effect there. I wanted a drum roll, but that'll work. Oh, I love it. This is a case filed in the state of South Carolina, county of Greenville, where I live, in the Court of Common Pleas, which is where civil cases are tried. First amended complaint. Charles Benjamin Ben Dickerson and Gail M. Dickerson, plaintiffs versus TLC Corporation, da-da-da-da-da, TLC Physicians, da-da-da-da-da, one of whom is mine. It's let's see, how many pages is this complaint? I didn't count them, but 20-page complaint. I'm not going to read it to you, I promise. I'd fall asleep. But I do want to just kind of give you a little taste. The plaintiff appeared at the offices of TLC in Greenville, South Carolina, April 17, 1998. Yes, we have a statute of limitations in South Carolina. It's 3 years. April 30, 1998, the initial surgery was performed by the physician. In the time period immediately subsequent to the initial surgery, the plaintiff had improved vision, had LASIK surgery. However, as time passed, the plaintiff's visual acuity worsened. Really? As a result, the plaintiff then had an enhanced surgery performed by this surgeon on or about August 25, 1999. This lawsuit was filed in 2011. As a result of the surgeries, the plaintiff developed corneal ectasia. Am I pronouncing that right? And y'all use these big words. It's just fun. Form, frus, keratoconus. Anyway. For a first, y'all in a world by yourself, I'm telling you. For a first cause of action, negligence/gross negligence. Ooh. At the time of plaintiff's surgery, defendants had a duty to meet the applicable standard of care in the course of providing medical services to the plaintiff, which duty defendants breached in one or more of the following particulars. I won't count them. It goes from A through, let's see, J, and J has 8 subparts. By failing to inform plaintiff of his specific medical condition. By failing to inform plaintiff of his medical condition and appropriate medical treatment. By performing the surgery which should not have been performed because da-da-da. And failing to obtain informed consent from plaintiff to perform the surgeries by 1 through 8. The decision not to initially inform the patient of his condition was deliberate and made no regard to, here it is, patient safety. I just gave you a little sample of something I'm dealing with right now. And that's complaint's a matter of public record, so I'm not breaching any confidentiality. I'm not going to tell you what my client said or who he was. This is where I want to stop because this is important and this is significant. And hopefully will be an encouragement to you. My partner and I have the privilege of representing a very fine cardiologist, 26 years in practice, never been sued. We tried his case this last spring in South Carolina. He had a patient, 56-year-old female, who 6 months before had a pretty significant CAD in 3 coronary arteries, including the LAD, which my cardiology friends call the widowmaker. Well, she was a female, anyway. So she had stents placed by his partner, interventional cardiologist, 6 months prior to my client seeing her. His partner said, "I need a right and left heart cath because of her symptoms. We got to do both." In attempting the left heart cath, my doctor inadvertently nicked femoral artery, unknown at the time. Did gain access, successfully completed the left heart cath and the right heart cath. Discovered that one of the stents, a drug-eluting stent, had restenosed in 6 months. That's the severity of her CAD. We got the diagnostic picture, recommended. You're not going home. We're gonna do heart bypass. She said, "Okay, fine." Within an hour of the heart cath, she began having abdominal pain. He immediately suspected a retroperitoneal bleed, a common complication to a heart cath. He ordered some fluids and ordered an immediate abdominal CT. Went with his patient to the CT scan, went with her on the street, walked her with the nurse to the CT room, was there when the radiologist read off the CT, said, "Yeah, we got fresh blood back there," and picked up the phone from the CT scan room and called the cardiovascular surgeon to come in and take care of his patient. Surgeon said, I'll be there. He immediately he calls to the floor and said, "I want to talk to the nurse that's taking care of my patient." Got the nurse on the phone, said, "Give this fluid, give this blood, our packed red blood cells, give this amount of fluid, do it now. Get it in there as fast as you can. You got to go up with a higher gauge needle, do it. Get this product in. Stat now, do it." Fine, okay. He goes back and takes care of some other heart cath patients who are waiting on him. Goes back and checks on the patient an hour later and discovers the nurse had not given the fluid and the blood products as quickly as he had ordered. Gets a bit exercised. As he said appropriately, "I was concerned for my patient." And the nurse didn't comply with my order. Of course, the family was there and going, "Oh, he got so mad at the nurse," So he said, "Get this fluid and get it in fast. It's way too slow." And oh, by the way, as a cardiovascular surgeon's going, "Oh, yeah, he came about an hour ago, decided not to operate." That's his call. They make that call. Why? Little known fact to me, probably well known to you. If you get a retroperitoneal bleed following a heart catheterization, you've got about an 80% chance of a spontaneous tamponade, just because of the tissue planes and what's going on back there. 80%. And the cardiovascular surgeons handle those complications all the time. What's the standard of care treatment? Give fluids, observe, watch it, and wait and go from there. That's their call. She in the next 2 hours, decompensated significantly and began a downward spiral and called the cardiovascular surgeon back in, gave more fluid, stabilized her. She died of a massive heart attack 2 hours after she was stable. sued my doctor. My doctor is a strong believer. He and his whole family. Had the privilege we tried it Easter week. I had the privilege of going to Monday, Thursday services with him. The trial didn't get over till Friday. We worshiped together. We had communion together. All week he prayed for that family that was suing him. Thank God he was praying for me to help him. The turning point in the case, in my opinion, was not my client's testimony, which was very good, but one of the plaintiff's experts got on the stand after the judge had ruled at the beginning of the trial, you can't get into evidence anything about the cardiovascular surgeons in the hospital settling their liability. So the plaintiff's theme was, we're here because this cardiologist didn't own up to his responsibility. But we couldn't get into the fact that the people that may have had some liability that we didn't think were liable may have screwed up. We weren't allowed to do that. It's fine. So my partner's doing an excellent job, as he always does, in cross-examination of this cardiovascular surgeon, plaintiff expert. And I mean, he withered the guy. I mean, the guy was testifying on direct, where the plaintiff asked him all the friendly questions. He was going, da 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 da. By the time my partner finished with him, he was like this. Yeah, okay, fine. I mean, he really did. He just withered the guy. So plaintiff lawyer, not to let it go at that, got up on redirect examination, the last bite of the apple, so to speak, his last shot at him. Well, doctor, you said the hospital, Dr. Foster wasn't responsible. Well, what about the cardiovascular surgeon in the hospital? What about that? Well, my understanding is that they settled the case and paid money to the family. Well, the judge wouldn't allow us to do it. He opened the door. We went through it. And I turned to my client sitting next to me, and he just looked at me, and he goes, answered prayer. And I go, amen. Well, the jury now knows all this, and the rest of the case was very defensible, and I think that was sort of the turning point. Good Friday, we got a good verdict. They returned a verdict in favor of my client, which they should have done based on the evidence in the law. We won the case. We should have won it. And my client, having prayed for this family that sued him all week, this lady died, went over as soon as the verdict was read and the jury was dismissed, walked the 3 or 4 feet over to the plaintiffs who were in the courtroom, spoke to him kindly, told him he was praying for him. They professed to be Christians. I don't doubt that. And when we went, he reconciled with this family that had sued him and put him through a very, very difficult 2 years. We went out in the hall late that Friday afternoon. Everybody else is pretty much gone. It's just us. And my client and his wife said, let's gather around. I said, okay. So we got in a circle and prayed. And he prayed for that family, and he thanked God for the experience that he'd been through all week, and prayed for the family that they'd find healing through this. That, my friends, is an Easter story worth telling. That's why I do this work. When I have the privilege and the honor of representing fine people like that and like you, and help you through this process. Thank you very much.